the voice of women in business. WASA's history dates back to 1980. WASA has over 8,000 members in 7 branches across the country. The organization was created as a platform for the inspiration and empowerment of women in business and in corporate South Africa through various initiatives to assist in the creation of professional and business connections and to access new opportunities. In line with its purpose, WASA, together with the Directors Association, is celebrating Women's Month 2021 with a series of online events designed for growth, inspiration, learning, and empowerment. Later on, we'll be taking questions from the audience, so please either raise your hand or put a question in the chat. Ntabi, welcome and thank you for joining us this evening.
Hi, Ruby, thank you for having me. Okay, I think let me just share my screen to start off. Okay, I hope everybody can see. Hi, everybody. My name is Ntabi Singh. I am director at Onyx Consulting Group. Onyx is an advisory and consulting entity that assists SMEs function at their optimal. We offer legal, financial, and strategic services. And this is for either startups or businesses that already started and are looking to expand. So today I have been asked to present a workshop that is going to be speaking to you on POPI. I think all of us at this point have either heard it or seen it. Some of us are well versed in it, while some of us are still struggling to understand what it's all about. So I am going to try and simplify it and take it from being a very legal concept to something that you can relate to and understand on a day-to-day basis. I just want to say though that the aim of this workshop is not to Can everybody hear me? Okay, I'm going to assume everything is fine. Okay, so just to start off, I would like to speak to you about a formula that I actually learned when I started studying law in university, and it's called the IPAC Formula. I still use it in practice today. It is a very good tool to help unpack certain problems, just in general, if you're into problem solving, or if you've got legal issue and you just want to simplify it because it can be very overwhelming. POPI is also overwhelming because it's just this big set of legislation. And if you haven't really interacted with documents of that nature, it does make it a bit difficult for you to comprehend what it means. And there's always an exception to the exception. So it will help you moving forward with any kind of legal issue you should have if you just want to understand it on a very superficial level. So the I in IPAC stands for issue, and this is where you need to identify what your issue is. And this is, most instances will be the problem that you're facing, or if you have a legal question that you need to have answered, and you would start there. It's very important to first understand what you're trying to answer before you go into it, because stemming from there, you will be looking at specific sources to help you answer the question. And if you don't get that right from the onset, it makes it very difficult for you to move forward. And then that does take us to principles, which is the P in IPAC, which is the authority or case law or any sort of legislature that you have available to you to help you unpack your question. Application is linking the issue and the principle together, and that's where you almost do an analysis. So in this instance, for instance, with POPI, we'll be unpacking what it is, who does it apply to, and why should you be concerned about it, or does it even have an application in your daily life? And then your conclusion is just to summarize your entire analysis that then gives you a very brief answer to whatever it is that you were seeking to answer. So I think with that said, I can actually just start with the presentation and we can look at our introduction. So some people call it POPI, other people call it papaya, but what it is it's the Protection of Personal Information Act. It was enacted in 2013 in November. However, it only, well, some of the important, or rather I would say the provisions that affect you directly now commenced in June, at the end of June, and that's why there was a lot of information flowing about it and a lot of concern in terms of what's the deadline, what must I do, what do I have to do. So the grace period was from June 2020 and it lapsed in June 2021. So we are in actual fact in the post-grace period. So most of us should be complying. And we'll talk a bit more later on in the presentation in terms of what that means, what it entails, and what is it that you need to do, whether in your personal capacity as a business owner, perhaps you are a compliance officer in an entity, this would also be then important for you. So if we're going to be looking at what purpose POPI serves, the act is in place to provide protection to personal information, specifically how we process personal information, and we also have to uphold everybody's constitutional right to privacy. I think we all know that with data and social media, it's very, very easy for you to get a hold of people's details. I think we've all received that annoying telemarketer phone call and you don't know where they got your number from, with somebody trying to sell you a product that you have no interest in. So, it's also to just assist to make sure that every information or all your personal information that's held by a particular entity is protected and processed in a way that you consent to and are aware of. The next bit is to look at how POPI, Okay, so what does POPI apply to? Sorry, I'm just struggling a bit with my computer. Okay, sorry, here we are. So it applies specifically to the processing of personal information that is recorded and used by a responsible party. That is a very technical, I suppose, definition or as explanation. We'll go into a little more detail for the key concepts for you to understand what it entails to be a responsible party, what actually is personal information, and when we talk about processing, what is it exactly that we are speaking to? So Section 3 makes provision for this, and I've tried to paraphrase what the application would be and what it should look like. So I think in terms of unpacking more of the key definitions in this paragraph, we will look at processing, and processing refers to any operation performed on personal information. Personal information refers to information that is identifiable to any particular person, but this will also include recording and keeping personal information on your premises and the deleting thereof. There are some exclusions because I know a lot of you will be interested. We live in a world where data is such a big part of our everyday lives. So does this mean when you're processing information in your personal capacity for yourself or for your family, do you also need to comply? And that isn't the case. So it does exclude personal household activities. So this is any notes or list of personal information that you would store for your private use. And then there's a concept for de-identified information. This is information that you've already either made public or has been made so that it's very general and does not apply to a specific person, not necessarily application, but I wouldn't be able to identify who it belongs to. So if I just say a Black 20-year-old female attorney, that could be anybody. It's only when you start putting personal information like my name, perhaps my identity number on my place of birth, my address, that you can then identify the information. National security, so if information is processed for a criminal record, and is necessary for the safety of the country, then there are certain realizations to its applicability. Journalists also have a code of ethics which exempt them from compliance with certain provisions, not overall. Art and literature is also another section where there are restrictions, and some of them are relaxed for processing information that's solely for an artistic purpose. So who does POPI apply to? That then also becomes a very interesting point of conversation. I would say it applies to almost everybody. It applies to entities, it applies to people in their personal capacities, and it even applies to juristic persons, which are companies. And in as much as juristic companies don't have or enjoy the same protection as a person does, they can also still have their reputation infringed on, and that does need to be protected. So they are included. But I'm going to give you some key capacities, I'm going to call them, that are defined in the Act a bit further. I'm just going to give a very high level that speak to who should be attentive to POPI, because it will apply to them. So the data subject is the person who the information relates to. So that will be you as an individual if the information that's being processed belongs to you. An information officer is the person who determines when and how the information is processed. An operator is a person who processes information or personal information on behalf of a responsible party. And I think the key definition here is a responsible party, which is the person who determines why, how, and how processed information is processed. So this would be your entity. So if you are a business owner, you would fall into this category. So like I said in the beginning, I think POPI applies to everybody. However, the capacity in which you have to comply or the capacity in which it applies to you will vary depending on your position in relation to the information. Okay. So then again, if I'm just going to go through this on a very high level, because I also think these are very important definitions. I didn't mention this in the beginning of the presentation. There is a very, very nice website that has the Act and the form of a website. I think it's papaya.co.za. And what that does is that it puts the Act in such a way that when you navigate through it, it's like going through a website that you would use for any other function. And when you open the tabs, it has the subcategories and subheadings that allows you to see which section you would be looking at any point in time. So I would advise that you have a look at it. It is very nice. It's easier to work with as opposed to getting the legislation via PDF. It is very dense, and if you don't have it in almost in chunks, it's very overwhelming. So even before you start to go through it, it will put you in a position where you just feel like, actually, I'm not going to do this because I can't. But it's a very great website, so I'd have you look at it. And I don't give the definitions as they are in the Act. Most of the time, I just, sort of summarize it. But if you want more information specifically to understand these definitions, it would be a very good place to start. Okay, so we are now looking at the key concepts. So personal information, like I said, is information that would belong to you in your individual capacity. But if you have de-identified that information, it doesn't qualify as personal information anymore. So like I said, if I'm going to be referring to myself, but I don't give information that's personal to me, but I still say that, I'm female and I'm Black, and I give my age, perhaps my occupation, it becomes very general. So if it's used in a table to capture certain information, just data or stats, if that information isn't there, then it doesn't become personal to me anymore. And then there's the concept around rights of data subjects, which I've explained is, the individuals that the personal information belongs to. You do have the right to have your personal information processed in advance with conditions for the lawful processing of the information. And we're going to talk about the 8 conditions which all entities need to comply with. I'm not going to do information in relation to children information that's considered special personal information. I'm just going to look at the very general sense maybe we can do another one later where we can cover that in a little more detail. And then consent in POPI is defined as any voluntary, specific, uninformed expression of will in terms of which one gives permission for the processing of their personal information. This is the rights of your data subjects with regards to direct marketing. A lot of us get these telephone calls where you have not consented, or you might have, signed up on a website to get specific information, and you get a pop-up question that asks you if they can continue to give you more information on products that they sell, or if they can continue to process your personal information. Most of us click it because you're looking for a specific thing, so you just want to get to the gist of it. But you cannot call people and sell products to them directly, either telephonically or through electronic means, to try and sell products if you don't have information to have their personal information on your database. So I can't sell information that we get through Annex to company X for them to then communicate with the client for another offer, unless if the client specifically consents to have that information processed on their behalf. And a responsible party must transfer information about data subjects to a third party who is in a foreign country. Sorry, you cannot, sorry. I made an error there. Okay, and then let's talk about private authorization. So I'm just going to read here. Should the transfer be necessary, the responsible party must obtain prior authorization from the information regulator. If this is contravened, the responsible party is guilty of an offense and liable to a penalty. We will talk a bit more about the information regulator later, but I think it's key for this to be noted. You essentially do need to get the authorization to process information to other countries. Then there's data breaches. Again, this happens often, and I don't know if you've personally experienced that, you must have, where you get emails, or if you have a business, have your server breached by a third party who's either trying to get information out, or they want to communicate to your clients to facilitate some sort of fraudulent activity. I think it is unavoidable to some extent for these things to happen. But if you are compliant with POPI and you have all the key things to protect the personal information that you process, and you act promptly when you become aware of a breach, you are in a better position, as opposed to an entity who doesn't comply with POPI, doesn't safeguard personal information that they process, and now is in a position where something has went wrong, and I'm able to link back that my personal information was breached at this particular point or from this particular entity. You would then, have to account to the information regulator. So the information regulator is a body that does, I think, two things that are the most important. They monitor the compliance and they enforce it. You will find that this is covered in Section 40 of the Act, because this is where it gets its powers and functions and the duties that they need to perform. Compliance, again, I think is key for entities. There isn't really much to do in your personal capacity, or if you are a data subject. But when you are an entity, you need to comply. We're going to go through that. There are a few steps that you need to take, or things that you need to be aware of. Like I said earlier on in the presentation, we're not going to cover Part B and Part C, and this is special personal information and processing information that relates to children. We're going to look at it in the general sense, because this is just to get a very high level understanding of what POPI is and how it works. So they are listed here. I'm going to go through them each in some level of detail so that you understand what it entails. Okay, so purpose specification refers to you being clear for the purpose that you're collecting the information to. So when you as a responsible party or as an operator are interacting with a data subject, it's imperative that you make it very clear why you're collecting the information and what it's for. You can't just request information and not clarify the purpose that it's going to be used for. And I think this happens sometimes when it's automated, like I explained before, where you're told, you're consenting to your information being used for future reference or future communication. If you are not in that line of business, this is prohibited. Processing limitations: you can only process personal information that you collect and that you have a justifiable reason for keeping. So if you are in the entertainment business, you cannot keep a individual's tax information unless if required for payment. I'm just giving an example. You need to be able to link the purpose to the sort of limitations that you get for the information being collected from the data subject. The third thing is further processing. Responsible parties must ensure that the further processing of information must be compatible with the purpose of collecting. So like I said, if I'm going to ask you when we are beginning to engage as an entity and you being the data subject, and I'm supposed to help you with a contract for a entertainment entity, I cannot later be asking you for you to provide me with your taxation information because there isn't a link. And if there is, it needs to be very clear how it's going to help me achieve the initial terms of our engagement. Responsible parties also have a duty to make sure that the information that they collect is correct and up to date. You cannot collect information that is misleading. So you as the responsible party need to take steps to ensure that it's correct. So just as a rule of thumb, I think it's always nice in an entity because, sometimes you have clients and you have the information stored, but you interact with them on a regular basis. I would advise that you perhaps on an annual basis request further information from them, or not further information, but rather an update of the information that you have in your possession. Openness refers to you being very open about the information that you're going to be collecting, what it's for, and how long you're going to be keeping it for. The section also has a bit where certain statutes or legislation require you to keep information for a specific time. For instance, I know the Law Society requires that information be kept for a period of 7 years. I know the Trust Property Act has a requirement for you to keep information for 5 years. So sometimes you will find that you need to comply from that perspective. I think it's important to be well aware of what the requirements are. And if you are keeping it for that reason, it's very clear that you're doing it for that specific purpose. And data subject participation, refers to your data subjects being informed of the process that you're going to follow to obtain the information. You need to advise them how they can contact you to correct the information if it needs to be updated. Security and safeguards refers to responsible parties having to ensure that the integrity and the confidentiality of information that they collect is controlled and safeguarded. And if it's not, or for any other reasons there are issues, you are able to take appropriate steps to ensure that you are able to get to a place where you are compliant. Like I said, when we're speaking on breach, I think in the modern world, it is very difficult to keep up to date with all the changes. I think with technology, if you move one step forward, they already find like 10 steps ahead of you. So it can become a bit difficult. But if you prepare the documents that we're going to talk about now, that you need to, and you are ensuring that you safeguard to the best of your ability, when there is a breach and you're able to justify how it happened and what you had done to prevent it, you are in a much a better position than a person who collects information, keeps it, but has taken no steps to ensure that the information is safeguarded. Accountability speaks to responsible parties ensuring that all measures that give effect to such conditions are complied with. So this is specifically the compliance, which are the 8 steps that we just talked about. There are some documents that you prepare to make sure that you're compliant, but I think more than it being a documentation or a processing of documents to be compliant, it's important that entities get to a place where they foster a culture of being POPI compliant. It's good for your business and it's good for your clients. And as opposed to it being just a one-time thing that I think most entities would have done to say, okay, you know, the 30th of June 2021 is coming to an end soon. Although we're post that period now, I need to do ABC to ensure that I'm compliant. I think it's key to ensure that you continuously monitor and update all this information. And at any given point, if one is to ask or have to hold you accountable, if there is a breach, you're able to say, on an annual basis, I review all my policies. On an annual basis, I review all the softwares that I have. All the passwords that I have for the different softwares that I use are changed every 3 months. Or there's a dual system that allows me to send an OTP to a cell phone if I am to access certain information. As is with anything, failure to comply does have penalties. You obviously don't want to find yourself in this bracket. The information regulator is responsible for ensuring compliance. Just to go through some of the penalties, the responsible party can be convicted for up to 10 years imprisonment if they are found to not be compliant. And I think they can administer fines, I think up to the value of 10 million. This obviously does depend on a case-by-case basis. And I think the information regulator is going to go through the process of what sort of breach, and if you are found, and that this will be developed on a case-by-case basis, this is the penalty that is suitable for the breach. It is a very new act, and I think the enforcement, to my knowledge, has not started to happen as yet. So it will be very interesting to see how the information regulator does do that. But those are the two most prominent things. So overall, I'd advise that each entity should have a checklist. And in your checklist, these are the things that I think you need to ensure that you have. You need to have completed your personal information impact assessment. This is an assessment that you must conduct to ensure that you have adequate measures and standards in your entity and you comply with the processing of personal information. This is something that, again, I would say you do either on an annual basis or when you're about to interact with third parties for a particular service and you're going to be interacting and exchanging personal information with them, just to make sure that they're also compliant. Because if they're not, then that is a point of risk for you. And the information and prior manual, most entities are now doing together. And I think you'll see in most websites that it is published. What it is just to explain to data subjects how you process information, the type of information that you keep, and also if they want to access information, how do they go about it? And if they want to contact your officers in regards to this, how do they go about doing that? Training on POPI is, again, something I think is nice to do on an initial basis if you haven't done it as yet. This just makes sure that there's synergy in the office around what POPI is. I think your operators need to know what the standards are and what they need to be complying with. And you can do this either through having workshops or providing documents like flyers that will speak to POPI. And having policy documents is also very important for the different types of information perhaps that you process, and having a skeleton that shows how information is received, what's the next step, what's the next step, what's the next step. So that even when you have new staff members coming and they are well inducted on what your requirements are and how you are complying with POPI, So just to emphasize, it's not just something you do once off and then it's gone. It's going to be something that continuously needs to be worked on. And like I said, because technology advances so quickly, you'd find that there is a gap. There's an opportunity for you to then close it in. Your assessment also assists with that. You can continuously look if there are any gaps in sort of your compliance or the way in which you do process information, and how do you then go about ensuring that you are not exposed. Cross-border data transfer compliance, that is because certain, there are restrictions in different countries. South Africa has POPI. Other countries have different acts that speak to their processing of information. So you need to have a document or a protocol of some sort that advises how you plan on interacting with countries that are outside of South Africa, and how you're going to ensure that you also comply with whatever the requirements may be. But I think the standard is more or less similar, but there will be different ways that each entity or each country goes about doing it. And the appointment of an information officer is something that every entity has to do. If you don't do it, I think automatically the CEO or the managing director becomes appointed the information officer. You go onto the website, the information regulator's website, to complete the registration. I checked this afternoon, and I think they're still having a bit of a technical difficulty with processing the registrations. So I think, although the deadline was June the 30th, there is a bit of a grace period. I'm sure they'll update everybody as soon as they have it up and running. But you register and you get a report. It's more of a certificate just to confirm that you have registered. In closing, I'm just going to close with this quote, and it says, "To be left alone is the most precious thing one can ask of in the modern world." And I think, everybody's privacy is precious to them. But because we share so much data, it becomes very difficult to monitor and protect it. Nowadays, you just need to do a Google search to find out a lot of information about a particular individual. You have social media, where even if I don't know you, if I follow you, I'm able to establish where you live, who do you live with, do you have kids? If you do, depending on how much you post, and I can keep track or keep updated in that way. And yeah, I think it's imperative that we all comply. And if you don't have to comply, be well informed on how POPI works, because you never know. Maybe you'll be in a position where you now need to lodge a complaint against an entity because your information wasn't processed according to the standards or the legislature, or there's been a breach and now you've been affected by that breach and you are looking for a remedy or some sort of recourse in your individual capacity. And I will be taking questions. I hope that has given you a very nice overview and summary of what POPI is and how it works, how it's applied, and what it means for you either as an individual person or a business owner or as an employee. Thank you very much, Rumbi. I think I will be handing back over to you.
Thank you so much, Ntabi. You've actually given me some stress, because I use a Swedish app called Truecaller, and you mentioned that the cross-border trading of personal information is not exactly legal, bar for certain scenarios. So what does that mean for Truecaller? Because I'm sure, as most people, Truecaller is a bit of a necessity in our lives at this point, and it's free. So what does that mean for those of us who use Truecaller?
But you use it as a way to identify a person who is contacting you. And does the person also need to have Truecaller? I'm not sure how it works.
Yes, the person would need to have Truecaller as well. So people with the app, they then show up on the app. So let's say I receive your number, but I'm not sure who you are. I can go onto Truecaller and it will give me your details.
I think then you would have consented to the information being shared And I don't know if Truecaller has an office in South Africa, but I think then they would have made sure that the policies are aligned with whoever the holding entity in the country that they belong to.
Okay. Do we have any questions from the audience? Please either raise your hand or pop a question in the chat. And in the meantime, Tabi, we do
yes.
Okay. Please go ahead and unmute yourself, Melissa.
Hello, can you hear me?
Yes.
Oh, hello everyone. How are you? I hope you're well.
Thank you.
I just want to ask something with that compliance checklist. That I forgot the full name now, but it's that PIIA,
Yes.
the assessment.
Yes.
Do you as a company do the assessment, or like are you supposed to get like a consultant or someone who like specializes in that?
That's a very difficult question to answer. I'm not going to say to you, no, you cannot do it yourself. I think if you're able to get yourself abreast with the information, it is something that you would be able to do. But I would advise getting a specialist or somebody legal to assist you with it. Or there are many entities now that offer specific POPI compliance services. You would then have an opportunity to present your entire case in terms of what your office structure looks like at the moment. If you are compliant, what sort of information do you process? And they would be able to assist you with ensuring that you're covering the gaps that might be there. You're welcome to approach an entity that specializes in compliance. Or an attorney's office who would be well versed with the act, and they'll be able to assist you also with something like that.
Okay, thank you so much.
Next we have Ndombi. Ndombi, please unmute yourself.
Okay. Thank you so much for taking me. Good evening, everyone. Let me appreciate the insights presented in the presentation. Well received, but also worrisome. I'm just thinking, what advice can you give to institutions, whether micro or macro, in terms of the functionary that can be designated the function? I'm thinking of small companies or organizations that might not necessarily have the resource to dedicate an information officer or something like that. How can they ensure that that function is being performed? But also, if the function, there's a designated person to perform the function, and the institution does not provide the adequate resources, how can that person try and ensure that does not take liability or responsibility for non-compliance?
Okay. I think there are a number of questions in your one question. I think to start off with, the easiest way to do it if you don't have resources, I would say, okay, well, let me start with this rather. If you don't appoint an information officer, automatically the managing director or the CEO of the entity becomes designated as the information officer. Now, if you're a small entity and you can't afford to have an entire department, for instance, that's going to be assigned to POPI compliance, then you are able to outsource the function from an entity like Onyx or the many other companies that assist with POPI compliance, or approach an attorney who would also be in a position, most likely be in a position to assist you with what is it that you need to do to comply. And remember, the smaller the entity, I would actually say the better, because you have better control of how information comes in and how information goes out, as opposed to an entity that's much, much bigger, where information flows through, a number of operators, and there are a number of systems that are also utilized. So I think the best way to ensure that you do comply would be to approach an entity that specializes in it. I don't know if that answers your question.
Yes, I'm answered on the first one.
Do you just want to repeat the second bit, because I think I might have then missed it?
No, I was talking about maybe in a bigger organization, they have designated an information officer to take care of that function, but the institution does not provide the necessary resources, in terms of all the requirements, the compliance issues. And now you are found wanting and penalties being imposed. How am I protected as a practitioner or an officer in that regard?
If you are appointed the information officer, it is your responsibility to ensure that there's compliance. So I'm not really sure if you can, then plead that you are unable to comply because you don't have resources. And if things are really that dire and you have an entity that is refusing to assist you or provide you with the necessary resources, I would then advise that you are better off approaching the information regulator just to say, look, you've got this issue and you feel as though when things do come back and there is an issue or a breach of some sort, you're going to be in the firing line. How best can they assist you? But obviously this is also going to compromise the entity. So I think it would be better to explain to them, this is the position that you're finding yourself in. And should they not be in a position where they're able to assist you, you have no recourse but to approach the information officer or the information regulator for further assistance or for them to intervene and see how they can assist the entity. Because when you say that the resources aren't there or they're being allocated, I'm not really sure, what that means. Is it just a resistance to comply, or is there really an issue of not having access to the necessary resources from a financial perspective? And I think then if that's the case, if the latter is the case, you have plenty free resources. The Act is free, and I've advised on our website where you can look. So I think it would be a very good start to sort of, say this is where how far you were able to get or how far you were able to comprehend and try and make sure that the entity is compliant, but you are restricted to get further advice, and your comprehension is limited. Although this will not, absolve you of liability when there is an issue, I can see perhaps in very, very dire scenarios, and this is also in my opinion, how that can be a mitigating factor.
No, thanks. I would love to have, because I'm thinking I'm operating the space of NPOs, where NPOs are keeping personal information. Yes. And in many times they have to get ID numbers, addresses, and everything. Now, in terms of the requirements of confidentiality, not declaring that information without due authorization from the people that they are assisting, those things can be technical for NPOs who does not have resources, or putting systems in place like technologically based systems that can assist them in that regard. That can become too expensive for them to do that. So those are the kind of organizations that I'm talking about, because I'm operating in that space. Thank you.
Okay, thank you.
Next, we have a question from William.
Okay.
Thank you. Thank you for giving me the chance. So, good question, Tavi.
Yes.
Regarding small businesses, right? I think social media has changed the lives of many business people. People are able to tap into markets using social media. And obviously, when you put up a page, people will follow you. But to what extent can you then tap into someone's profile and then use that information? And will that be in contravention, given that that person chose to follow you in the first place?
I think information that's already in the public space does not qualify as personal information with regards to POPI. So you would be covered if you're accessing it because it's already on a public platform. It's different if you would be getting it from somebody else who would have to give it to you because you wouldn't have access. So some people have their pages as private. I think Instagram and Twitter provides that function. So you wouldn't be able you wouldn't have access to them or their personal information, but you could potentially ask another person to, take that information down for you. So it just depends on whether the consent is there. And if it's already in the public space or on a public platform, then it doesn't qualify as personal information with regards to POPI or in relation to POPI.
Okay, awesome. Thank you so much.
Thank you. Next, we have a question from Jenny.
Thanks very much. So I wanted clarity. I've tried to access the website as well to register information officers. It seemed not to be working. So I wanted to ask, in your opinion, has it ever worked or no one has actually registered anyone on that website to your knowledge? And then the second one is, so in the event that that is not working, what then? What's the next step? Do we just keep it to ourselves that this one is the information officer? And what mitigation steps can we take in terms of the registration of information officers?
Okay. The information regulator has extended the compliance with regards to the registration, because it was also up until the 30th of June 2021. But because they were having technical problems, they've almost made it open-ended so you can register at any point in time. Like I said, I tried this afternoon, and I do think they're still experiencing some glitches. People were able to register, I think, only as far as April, and I think after April, that's when they sort of started, I could be wrong, but that's when they started to experience some technical problems. You can also publish this information on your website if you do have your website. You would have your POPI or PIA manual on there. Or if you've published your PIA manual, you would update it, and that will also be available on the South African Human Rights Commission, their website. Or there's a process you follow to get the information. So the easiest way would then either to put it on your website. I think there's a tab where you can email the information regulator directly. I'm just not sure what the turnaround time on that is, because I do know that they're still trying to scale their capacity. But I think those would be the options that are available to you right now. But remember, just because you haven't registered, it doesn't mean that you're not compliant with that specific provision, because they are the ones who are experiencing some problems. And like I said, they've extended the deadline as opposed to it being cut off on the 30th of June.
So Ntabi, I would like to know, with regards to the telemarketers that call you asking if you want to have an extended motor warranty, etc., what recourse do we have against unwanted calls? And like, for example, I received a call this morning, and at the end of the call, they asked me if I'd be willing to give them the details of 5 other people who might be interested. So what recourse do we have? And also, what implications are there for those companies that are still requesting personal information, even though they're not supposed to be able to access it in that way?
Yes. Okay, so if you already have an existing relationship with the entity, then chances are you've consented to them communicating with you, right? But if this is an entity that you've never communicated with, then you should be asking them where they've received your information, and you are in a position then to report them to the information regulator to say, I got a call from X, I don't know where they've received my information, I did not agree to it, and your privacy has been infringed, and they would then commence with an investigation to find out what's happening there. And obviously you are not in a position to give information about further people because you don't have consent. They would have to ask them directly to say if they're agreeable to taking the call, explain what the purpose of the call is, and then explain that I want to take your information and this is the reason why. And they would ordinarily have your number for another function, but it has to somehow be related and make sense. So if it's to extend on your warranty, like you're saying, you would already have a warranty with them. So it's in connection with a product that you already have, and they have information for that particular product. They just want to extend it.
Okay.
I hope that answers your question.
No, you have answered my question. I have another question.
Okay.
So does it have any impact on marriages, people who are married in community of property or out of community of property, in terms of maybe filling out a form and providing information without necessarily speaking to your spouse?
So you're asking if you've got agency to provide information on behalf of your spouse? That's actually a very interesting question. And I would like to look into it, but off the top of my head, I would say no, because it's still not your information. It would make sense to ask the subject holder directly. I don't see how you would have paxed your agency over somebody else's information.
And to extend the question with regards to minors, let's say children, for example, do you then automatically get agency as a parent or a guardian?
Yes, but there are certain protocols that need to be followed. I didn't cover them in this particular workshop. We can look at them if it becomes a point of interest, but that's governed sort of differently, and the way in which that information is processed is also quite different to make provision, because there are minors and they don't have agency in certain instances. So if a child is to apply for something, the parent would be doing it on the child's behalf because they are a minor and they won't have the capacity to do it on their own. And I think that's why it's sort of a separate section as opposed to be made, for the provisions that make for the general processing of personal information.
Thank you. Do we have any more questions from the audience? Please either put your hand up or place a question in the chat. There's a comment from Jenny saying, interesting question regarding the information about the spouse.
I agree. I think that is a very interesting question. But as I'm saying, off the top of my head, I would say no, because I don't see how you would be acting as the agent unless if they've given you consent to do so.
So you can't surprise them with something then?
Surprise them in what sense?
I can't think of an example off the top of my head, but in an instance where you'd need to, you'd want to surprise your spouse and, you have to provide their information for that to happen.
Yeah, that is very interesting. I'm going to have a look at that. I think maybe we can post it down on the comments at a later stage.
Okay.
But yeah, it's interesting. Yeah, I'm going to have to look at that a bit more.
Okay. If there aren't any more questions or any more hands, then I think we can close. Just going to give it 10 more seconds. Okay. So on behalf of BOASA and Directors Association, I'd like to extend a heartfelt gratitude to Ntabi for taking the time to share her wisdom with us today. Thank you to all of our partners, and thank you to all of our viewers for joining us this evening. Please go to www.womensmonth21.co.za to sign up for the rest of our Women's Month events. If you would like to know more about securing a BOASA membership, please drop us an email at boasagp@womensmonth21.co.za. That's BWASAGP@womensmonth21.co.za. Thank you, everyone. Bye.
Thanks, Rumbi. Bye, everybody.
Thank you all. Bye-bye.
Bye, Ntabi.
Bye.